let me just kick it off and say thanks to everybody that's here. We appreciate your interest. We'll do our best to keep it light, keep it real, and answer your questions best as we can. And if we need to defer to legal, our in-house counsel, Dan Withers, is on standby.
I was going to say, is he here?
No.
You didn't invite him?
No. But I'd like to give a shout out to Steve Lefave here because he's been my right arm guy, my main bud, wingman for 20 years almost, 18 years, something like that. And we're
retiring together.
Steve is the bomb, and he's been such a huge help across so many fronts, and we bounce things off. So some of you know that. Some people take the shotgun approach when they send questions. It'll come to both Steve and me, or Steve and me, and Todd and Rolf and Jess and others. But we do, whenever it's important, if I have doubt or if he has doubt, we collaborate. We talk with Dave Werfel, Sarah, Donnie, all for good intent to try to give the best experience pay it forward as best as we can. So it's been a lot of fun for a lot of years, and I'm really enjoying keeping it going with Steve after 18 years. So, yeah.
How about this guy? Right?
Yeah.
Oh my God. Jesus Christ. I mean, where would we be today if it wasn't for this guy?
Yeah, I don't know.
I mean, holy Toledo. So, and then they moved me right next door to him. I used to be on the other side of the building, right? Then they put me right next door to him. I can't get in and out now without being seen.
Chantilly broke a row with Dave on the end too. So this is going to be free form. It's designed to be, open Q&A, and try to stump us. I will readily pass the buck and take Steve's lead if it's something that I don't know, and I think he knows better, and we'll just roll with it. So I know that we've got talking points in case you all are dumbstruck and don't have any questions for us. But
I'm just here for eye candy.
yeah.
Yes, Steve.
So why don't we just open it up? Who here wants to go first with any question about best practice, company policy, strategies, contract stuff, legal?
All right.
You name it.
Hey, I'll start it off. You want me to start it off?
All right.
All right, I got a question for Mike. Mike, my seller remains in their house after settlement on a seller's post-settlement occupancy as part of the sales contract. After the seller vacated, the buyer wanted all their security deposit for issues that were pre-existing things and had nothing to do with the time period between the settlement and the end of the occupancy agreement. Is that okay for the buyer to do that? If so, what can be done, or if not, what can be done to resolve that type of tactic?
So the old seller post-settlement occupancy agreement dispute, we see it all the time, week in and week out. And I'll just offer this up first. A lot of attorneys, including former NVAR general counsel and others, strongly advise just avoid the rent backs altogether if you can. We know that that's impractical, but they really do turn into a can of worms, as many of you know. On that question, the buyer is trying to hold the seller hostage over some of the rent-back security deposit, and it's unfortunately for the parties, more often than not, those things are going to come down to a negotiation, a split, because the escrow agent is likely to never release the funds to either party without mutual agreement. Contractually, what I would say is agents really need to always look back to what the contract says, right? And Steve and I deal in the context of the NVAR rent-back agreement, seller's post-settlement occupancy agreement, which is a little bit different than some of the other associations. Some folks are in from West Virginia and use, I guess, the Eastern Panhandle Board of Realtors form. Others use the CVR MLS form down in Richmond, or the VAR form, what have you. And all those out there in Maryland, good luck to you. But there's so much to it. If you're a buyer agent, and I advise our agents to counsel their buyers not to play games. We don't want buyers getting ahead of themselves and trying to extract, or extort money that isn't deserving. So we see it a lot more when there wasn't a home inspection contingency, right? And that's been kind of standard fare a lot of the time for the last many years. And that can create additional problems if there was not a home inspection contingency pre-settlement, because that means there was no third-party professional record of what the condition of the property was. In any event, all buyer agents should always be doing their pre-settlement walkthrough, of course. Sometimes we see agents thinking that they don't need to do a pre-settlement walkthrough because there's going to be a post-seller occupancy walkthrough. Don't ever, ever let that happen if you're a buyer agent. And if you're a listing agent, I would not enable that either. It's in everybody's best interest to have the pre-settlement occupancy, the pre-settlement walkthrough documented on a written form. We have standard forms for that because that'll lower the chance of dispute. Beyond that, Steve?
I think you hit it.
I mean, it depends on the item. You got to look, what is the document? Well, the main contract says the seller is going to deliver the property in substantially the same physical condition as of a certain date, and that's usually date of home inspection, but it might be date of contract, and it might be date of settlement. Mm-hmm. But fundamentally, that's your first threshold, and the seller should return it to that condition, and either that or the final walkthrough inspection that's documented. So,
all right, thanks.
This does seem like a good time to point out, too, guys, and Sarah sent out emails about this. Remember, Samson encourages your buyers to hold their EMDs with us, but post-settlement occupancy deposits, we do not want to hold.
Thank you.
We do not want that.
Everybody get that?
Hey, wait, that's one of my questions.
Nope.
Why are you getting ahead of me?
I have some supplemental questions for you, Steve. Don't worry.
All right.
We try to hit on that a lot. We want those seller post-settlement occupancy security deposits with title. But we recommend contract earnest money with Samson. Yeah.
Hold on. Get a mic.
Get a mic.
Oh.
Thank you, Adam.
We just had a post occupancy on a house just last week, and what the sellers actually did, which I've never done before, was took pictures of the damages at the pre-settlement walkthrough,
right,
so that it couldn't come up on the pre-occupancy walkthrough at the end of the post-occupancy date.
right.
So they actually have pictures included with that walkthrough, which
Great idea.
I'd never thought about it, but it was a good idea.
That is
You know,
a
you
great
guys
idea.
think about it. We do more of that with rentals than we do with sales, it seems, right? We document the condition with rentals, sometimes better with photos and all that. So there should be more of that.
And it is,
Thanks.
and it is the like if there is a dispute, it is the buyer's responsibility to show that the issue wasn't there, whatever, say during the home inspection or during the contract ratification period or prior to the post-settlement occupancy. The onus is really on the buyer, right? So if the buyer doesn't have that proof via a report, hey, we did a walkthrough, the microwave was working, and now it's not working, and the seller's telling you, no, that microwave's never worked. What are you talking about? If you didn't note it on any type of report when you did your pre-settlement walkthrough, then where's the buyer's proof that it wasn't working, right? So, all right, there was a question. I saw one.
I
Hey,
want to
Jess.
keep going on that a little more. So if it's one word against the other, the buyer against the sellers, just, but there's no proof of anything. And what happens to the money? How do they get it? What's the next step after there's no meeting of the minds? They haven't come to an agreement.
Yeah.
Do they then contact court? I mean, what happens next? And, what do we...
Call Steve.
Right. What do we say?
Wait. I thought you said
Call
you had.
Sarah.
I thought you had Dan on.
Wait, does that mean you're stumped? I stumped them.
I thought you said you had Dan on retainer.
Yeah, right. So let me dive into it. you know, there's a lot of brokers and, you know, respected attorneys, and including some with our associations, who would say our job is done when we go to closing, right? And don't get involved. Don't get involved in these post-settlement occupancy, release of deposit disputes, because that can create additional liability for us or whatever. Our job is done when it goes to closing. But we all know that obviously we're in the service business, so we're going to go the extra mile, and highly recommend that you do go the extra mile, but based on a discussion with your client that it's going to be very, very limited. You know, you can't solve the problems that have to be, these disputes that have to be resolved between buyer and seller. And that's why 9 times out of 10, these disputes end up in a split of the funds. So easiest way to avoid that is not do the rent back. But all you can do, Jess, right, is document on that pre-settlement walkthrough as best you can. Photos is great. If you're, obviously, if you're a listing agent and you're receiving offers that accommodate your seller's request for a rent back, you want to have a higher security deposit. If you're a buyer agent, you obviously want to have a lower. I'm sorry, if the other way around. If you're the buyer agent, you want the higher security deposit. If you're the listing agent, you want as low as you can possibly get. If I were a buyer or a buyer agent, I would rather have a bigger security deposit along with 0 rent back charge than rent back charge with 0 security. You know, we do get sucked into broker to broker, you know, resolution attempts, and I cut that off pretty quick, I'll tell you that, because there's only so much we can do, and we're not attorneys, and they got to work it out. So I don't know how to put it any other way.
Ultimately,
Yeah,
I would
they
say
added that
just
language on the post-settlement occupancy agreement now anyways, right? So
Yeah.
that it's perfectly clear it's between the buyer and the seller.
yeah, you know,
Well,
ultimately.
I'll be damned. Look who's in the house.
I'm Mr. Samson's
Look who
here.
came in the room. How about that?
Yeah, I wasn't talking or anything, Donnie. Just saying.
Sarah?
I know it's just Sarah. I would say, you know, yeah, the language changed. So I think that's a great point that Steve brought up as well. However, I would also say to you, at the end of the day, the least amount of stress that your clients are going through, and the more you can do to not create yourself liability and not necessarily, you know, put your head through a wall because nobody will talk to each other. But the more you can do to reduce the stress that your clients are under, the better experience they will have, and the more likely they will be to use you again because it's happy and not so stressful. I think sometimes you also just have to say to them, look, you in principle can be right all day long, but are you willing to spend $30,000 to go to court to have an attorney fight it so that you may have this $1,500 back? Like, at some point we need to use some common sense, and can we just agree to split in the middle? If they will agree to split in the middle, and then can we just call that done? And at the end of the day, if it's not done and everybody wants to stick on principle, you do the best you can. You tell them, hey, look, I hear you. Fundamentally, I feel like you're right. I'm not an attorney. I can recommend you to an attorney. You too can spend $30,000. Let me know how it turns out. And we will hold the money for 3 years. And if we don't get some kind of resolution by the court or you agree in writing, then we're going to interplead it to the state. And then you get to go to court again and have that money and make your case. And nobody will have it for 3 years. So, you know, I think the best that you can do to kind of keep that experience that you have with your client smooth and easy and as stress-free as possible always makes the client win, and frankly, you too, and your stress level at the end of the day.
One more thing on rent backs I'd like to say, because we see this, and you know, it surprises me when I see it, but until you go through it, you might not know. If you have a tenant-occupied listing, don't use a seller rent back. We see that, you know, where the investor is, or whether it's an investor or not, it's usually an owner-occupant buyer, but there's a tenant, there's an existing lease for another month or two or whatever, some period of time. That's not a seller rent back, so don't use seller post-settlement occupancy agreement for that. Use a short-term lease, okay?
Right.
All right, Pam Mooney.
Mike are up.
I'm going to go back to what Danny Samson told us like 20 years ago and be proactive. If you have a buyer and you do the walkthrough before settlement, I video everything, floors, walls,
Yeah.
everything that's running, you know, if it's a gas stove, temperature, everything. And if you have issues when you go 2 months later and anything's not working, you have documentation to show.
Get it in writing. It's always.
Right.
And you know, a lot of people think, a lot of buyer agents get all flustered and angry when a seller won't sign off on that pre-settlement walkthrough inspection report. In my opinion, if you're a listing agent, I would encourage you strongly to have your seller go ahead and sign. If they're taking issue with anything that's on there, then speak now. And go ahead and sign it for the record, but you can't force them to, and it doesn't mean it's going to kill the deal or anything like that. So a buyer should just proceed to settlement. The main thing is they documented it and they provided it.
Come on. The other great thing about having those documents signed is, in a lot of cases, the home warranty companies right now are saying, well, you don't have an inspection. How do you prove that it was working and it wasn't broke?
Right.
Well, if you have those inspection documents for settlement, you can send that and say, see, the buyer and seller both,
Right.
and we have that proof now. So we've used those a couple of times when home warranties haven't wanted to kick in because the inspection contingency was waived.
All right.
Who's got a question? Something else? Anybody? Hey, Sam. Yeah. For those of you who don't know, Sam, our new Gainesville branch manager broker. Thank you.
Hey,
Sam
thanks,
Hardman.
So we had a tenant applicant this morning applying to rent a house, and the listing agent said we won't process it until you send us copies of their driver's license.
Is that okay?
Is that okay? They see their names. They have their social security number. They can pull
Yeah.
social. Is it?
So,
are you just looking at a picture?
I
of the
will,
person?
let me just preface this by saying, please all keep your eye on our calendar for our session coming up at the end of the month with two attorneys from NVAR who are going to be talking about rentals and fair housing and service animals and all kinds of stuff. Because I think, Sam, where you're going with that is, could that present a potential
Fair housing
question about discrimination based on the photo ID?
Uh-huh.
Personally, I'm not a hand wringer. I've never been a hand wringer. I, of course, have full respect for federal and state fair housing laws across all fronts, but photo ID, yeah, it's expected.
All right.
Right.
I mean,
You know, they
an
also
evolving thing over time.
And they also have to upload those. When you use platforms like Rentspree, they ask for now they use it to verify identity when they're running the background investigations, and you don't necessarily send it to the client, but they do ask for that government ID on those uploads.
Right. Well, a lot of this too stems over from the paper NVAR application, which used to ask for the driver's license and used to provide the application fee and a check, which was considered earnest deposit, right?
Yeah.
So we have a lot of folks that have been around a long time, right?
Your
So
state
they
and your age
still
there,
want
Steve.
all that stuff, right? They want driver's license, they want a check, and we're finding tenants are a lot more reluctant to provide that earnest money deposit check out front, which is not a big deal, as long as you get it prior to ratification of the lease. You're still fine, but as far as a lot of those things were required before, and that's why people still require them. I mean, I still ask for them as well. I mean, when I get a rental application myself, I ask for copies of their driver's license or passports. If they don't have a driver's license, I ask for copies of their either W-2 or whatever, their monthly statement if they're W-2 employees, their Schedule 1099 with a C if they're independent contractors, and any other pertinent information that they can provide me for their financials in order to properly evaluate their application. So as long as you ask for the same thing every time you process an application, you can't go wrong.
Sam, was this a real case, and were we on the listing side or the tenant rep side?
We're on the tenant rep side. Yeah, it's a real case.
Was there an objection from the tenant or from?
No, I was
the
just
agent?
curious.
Just curious.
It was an agent that's been around a long time, was still using the paper form.
Yeah.
It had the driver's license numbers on it and had the social
I
security
mean,
numbers on it.
I've never really used Rentspree myself. or Appfolio myself, but
Rent Spree is fantastic, and we're actually going to have another class coming up, but because a lot of people don't know that Rent Spree is the platform that Samson uses to
Yeah.
process our listing agents for our rentals. That is the platform we use. So we're going to have a class coming up on that. I just talked to her this
and it's
morning.
got
It'll
the
be
ability to
soon.
upload the driver's license.
It does, and
any
it
other
asks for it.
document.
Yeah,
It does not.
Okay.
it does.
Well, Rent Spree Pro.
So I just did one this week, and it is in they had to upload the driver's license as part of our platform. Now, I didn't get a copy of that. It's not part of the application.
Right.
It goes to verify the information when they run the credit checks on the back end.
Right.
So what comes to my mind with this also is the question of love letters, right? We get that question, and some of our competitors, perhaps some brokers that you all have been with prior to coming to us, or you're aware of some brokers, or maybe you even have your own personal, professional position on it, which you're entitled to have, as to whether or not to allow these love letters with photos, for example. Whole nother subject, but it's something that we don't have company policy on, saying you can't do it. But it's along the same lines. It's like, particularly before a contract is ratified, a lot of people feel, whether it's a lease application or an offer, that it's best to keep it to the numbers and the terms only. Why bring in, somebody's photograph or their family's photograph or whatever? On the other hand, some of our clients know that it can work, and it has worked for their friends and family. And so if anybody wants to talk about that stuff, it's similar to that question. Happy to take it later from anybody. Okay. So who has a Stump the Broker question?
Hold on. One back there first.
Okay, I don't know if this is a stumper, but it's the three-parter. What is the redemption period for a foreclosure in D.C., Maryland, and Virginia?
Well, Steve, I told you some I would pass over to you, or you can hand out
That's
to
for
Dave,
Mike.
because Dave is a DC broker. I'm not. Neither is Steve. But yeah, redemption period. So I'm not licensed in Maryland or DC. That's a good question, and we can research it and get back to you, Beverly.
That is stumper.
That's a stumper. Give her a prize. If anybody in the
Do
if
you
anybody
want
in the
me
room
to
knows
give
the
you
answer
the
to that.
answer? Yes, I do. There's no redemption period in Virginia. There's no redemption period in D.C. There's
Yeah.
180 days in Maryland.
All right.
I thought you were going to say D.C. It's like with the TOPA laws down there. I could see them giving somebody a redemption.
Testing.
All right, Dave Werfel
Hi, Mike.
next.
Oh, somebody else?
Hey,
Okay, hi,
Valerie.
Mike. This is not a real case, but something you said made me think about it. What if a client wants to rent a house and the owner says no pets, and the tenant has either a service dog or one of those emotional pets?
Yeah.
Do they have the right to cry discrimination if the owner, the landlord, doesn't want to rent to them? Or do they have the right, does the landlord have the right to put them out if they move in and now they get an emotional pet?
So this is one where I kind of long for the old days when we didn't have to deal with this stuff, but it is real, and good question. And
tune in when we have the attorneys. No.
that's right. They're definitely going to be talking about this in more depth, because it's, as everybody knows, a source of confusion on what's okay, what's not okay. But to try to get to your question, it is challenging. We are seeing and getting questions about rental applications that come in with no mention whatsoever to a service animal or ESA, emotional support animal, service animal. And legally, they don't have to. If I'm a landlord, I don't like it. I mean, I would prefer that they share that up front, but there's reasons why they don't have to. They don't have to share. Here's my rental application, and oh, by the way, I have a legitimate service animal or emotional support animal. So sometimes it comes out. This is increasing, by the way, and it's like word gets around, the internet or whatever, people doing their research, and a lot of them are completely legitimate, of course. But a lot of them aren't. There's a lot of bogus situations going on out there, and they, some folks come to find or believe that they can get away with anything because everybody's scared over it, right? And so you'll see increasingly these situations where after the landlord or the listing broker or property manager has given approval in writing, maybe the lease isn't signed yet, or maybe it has been. Only then does it become known to the landlord, listing agent, property manager that there is such an animal in play. And I'm not an expert on it, but the landlord and the listing agent have the right to require reasonable documentation on what it is. Is it a physical support animal, emotional support animal, service animal, and how is that animal or the need reasonably certified? Who says so, right?
Right.
It could be, and it doesn't have to be doesn't necessarily have to be a mental health professional or a doctor, medical doctor, or it could be a social worker, I think. It's pretty broad, but I would ask everybody to research your local association of realtors, websites, and the forms. We have forms in SkySlope, at least NVAR does, where there's a, a service animal approval notice or a service animal denial notice.
And a lot of those
request for reasonable documentation form.
Right.
These forms are available to us, and on the NAR site and the Virginia Realtor site, I know for a fact that there's a lot of good information that's, more. It's more credible than what I can tell you because it's coming from the attorneys that represent us in our membership.
So why don't they tell up front? Do you know?
Well, no.
So
Again, so this wasn't a real case, but just say like to the points you were making, Mike. So say if a tenant moves in and say they go to the hospital, they think they're having a heart attack, whatever, right? And their doctor says it's stress, right? So they decide the doctor is going to give them the permission to have an emotional support animal. So at that point, if there's no mandatory requirement in the legal document saying now this person has to come back and give that information to the landlord, then
legally, I don't think they have to even tell the landlord it's not a pet. Mm-hmm. There's no security deposit. You cannot collect.
There's no pet deposit.
I'm sorry, pet. There's no additional pet deposit because the law doesn't see it as a pet. We have seen that where existing lease. And the landlord calls up our listing agent and says, hey, I went by the property and they got a dog in there, right? What's up with that? And because they always like to look at us as their property managers, right? Even though we're not. But, that would be a case where the landlord, of course, would have the right to say, show me your legitimate paperwork. Sometimes you get into this debate over whether it's fabricated, fraudulent piece of paper off the internet. And if they don't produce it to the landlord's satisfaction, then, the landlord can move to evict if they don't get rid of the animal, if they can't document that it's legitimate.
So a lot of people don't tell up front, right? Because as a reviewer of the application, you can't reject someone because they have a special needs animal or a service animal, but you can reject on a whole host of other stuff, right? So what these folks are finding out is if they don't disclose the fact that they have an emotional support, and normally service animals are a lot easier to, and those folks normally let you know, but the emotional support side is a whole different scenario, right? So they don't let you know because they don't want you to deny them on other facets of their application, i.e. credit score is too low, i.e. they don't make enough income, i.e. whatever it is in their application that you can find in order to, because the landlord is shouting in your ear as the listing agent, they don't want an animal in the house, right? So that's why they don't tell you up front that they have it. Yeah. And then they normally tell you once they get that acknowledgement that their application has been approved, where you can't come back later on and say, oh, by the way, we notice your credit really isn't that great, so we've decided we don't want to take you. Now you're setting yourself and the landlord up for a potential Disabilities Act violation, right? So, but I would also argue if they wait all the way to the time where they're in the property, there's a clause in your lease that says that everything they provided you in their application was truthful and all that kind of stuff. Well, if they didn't disclose the fact that they have a special assist animal or needs animal and they show up to the property on the day of their move-in, you could theoretically say that they weren't truthful in their application process. So that could offer a whole set of problems for the potential tenant. Now, as far as when you have a tenant that's living in the property and they call you up, say as an owner or a property manager, and they say, hey, Steve, I had all these issues. My doctor recently prescribed that I get emotional support animal. Of course, you can verify all that stuff like you would normally. And then also, there is a little leniency in there where the landlord can ask for certain accommodations be made, i.e. if there's hardwood floors in the property and you would like those hardwood floors to be covered up because they're going to get a 6-month-old puppy dog or whatever, you can ask, could you please put some rugs down in the high traffic areas in order to mitigate any damages to the hardwood floors. So that kind of helps in that transition as well. But it's not good for a tenant if you show up and you're the landlord and you walk in and they've got a dog and then they say, hey, oh, by the way, 6 months ago I got permission from my doctor to get this. You do have a little pushback from the landlord side in order to, you can't evict them based on it, but it's something that they shouldn't do. I mean, despite the fact that it's not a pet, it's still supposed to be a notification to the landlord because it's the landlord's property, right?
Who's up? Rolf.
Right. Got
Hey,
one
Rolf.
here. As long as we're on rentals here, I just have a question regarding the current listing agreement for rentals. Paragraph 5, we asked the landlords about their situation with if they're going to be willing to accept Section 8 housing voucher, etc. But that, if I understand correctly, is no longer something we can discriminate based on. Why is that in the listing agreement? How are we addressing that? Why are we addressing it if it's something that can't be discriminated upon?
Well,
So
the first part of that is, right, a landlord can still not accept Section 8 housing if they own less than four investment properties. So that's why the box is still in there. But if they do have more than, they can choose to, if they decide they want Section 8, they can choose to accept Section 8 applicants if they have less than that amount. But over that amount, they have no choice. They have to entertain all avenues, and they can't discriminate against someone due to their source of funds. And that's how this would be. Section 8 housing would be source of funds, right?
are you speaking about the latest NVAR exclusive right to lease? Yeah. I'd like to look at it more carefully, but I know they did want to clarify for people that the law does not apply to some of our clients that only own 1, 2, 3.
Right.
And we always get confused. Is it more than 4 or 4 or more?
No, it's less than 4.
Less than 4. Less than 4 in this case. It doesn't mean, we would always advise our listing agents, don't be, you want to give your landlord client, your valuable client, your best honest advice based on your experience. But there's plenty of landlords out there that have had great experience with housing voucher programs. Others haven't. So it's just, I wouldn't be passing judgment. It would be wrong for you. It could arguably be unethical for you to categorically say, stay away. Even if they can, because the law doesn't apply to them if they only own 1 or 2 or 3. It's case by case, and obviously the total application package is important. Some landlords have found it's really nice to get that monthly rent every month from the government. So. Hi, Cece. Yep.
Now, I have been taught that somewhere along the line that listing agent discouraging to landlord to go Section 8 because county, whatever jurisdiction they are in, and I have to inspect periodically the property, and then tenant tore up the property. Section 8 is nowhere near to take care of any of those. So they say it is too much hassle at the end, 2-3 years and no big thing to paying rent, but they're tore apart, nothing they can do about.
This was one isolated landlord client? Is that you're referring to a former client?
No, I just was told along the way, that's why they're discouraging it.
Well, that's a common perception. I would say that there
So
is
anybody
concern,
have
but
any experience on that?
some people believe that, but they should only believe it based on their own individual experience, I think. Every landlord's going to be different on it, and each housing voucher occupant or applicant is going to be different.
Correct.
How many kids do they got? Do they have pets? I don't even think most of the voucher programs allow pets. Maybe they do, but it's case by case.
Could I go back to the question about the service animal or emotional support animals?
No.
So
Go ahead.
basically saying, as a landlord rep, doesn't need to know whether they have support animal or emotionally support animal. They don't. I mean, tenant to be not have to divulge that information.
That's what we
beginning
said
is
earlier.
okay?
Legally.
So I want to clearly understand that.
I believe that the law does not require that. It's not a pet. They have the legal right. It's a real judgment call, especially for tenant agents. Are you going to encourage or discourage your applicant to speak about it at that stage in the application or not? The hope is, of course, that the tenant applicant, as we said, they don't want that to be taken into consideration, of course, because they know that tenants with pets are going to get rejected more often than those without pets. And even though the law says it's not a pet, it's an animal. So the answer is they don't legally have to disclose it.
So you can't kick them out.
No, you
afterwards.
can't.
No.
No.
Let's move on to something off of rentals.
Wait, I got another rental question.
Okay.
I got another rental question for Mike. Mike, the VRLTA says that an individual non-resident of Virginia who owns and leases rental property in Virginia will have to continuously maintain an agent who is a resident and
Yep.
maintains a business office in Virginia. Can you explain what that means for my clients that live out of state? Does having a property manager in Virginia fill this requirement?
So I don't know how West Virginia law treats it or Maryland or DC, but Virginia law does require specifically any out-of-state landlord, no matter how many properties they own, to have a resident agent. It's not called a registered agent, it's a resident agent. And it's the primary purpose is for service of process. It's like a registered agent. Samson companies, of course, any company or LLC has to have a registered agent that's identified in the Virginia State Corporation Commission records. Similarly, and this is not widely known, resident agent, because it's not widely known because it's rarely done. And a lot of realtors don't know about it, listing agents. You should be reminding your landlord clients when you take a listing, get it nailed down when you take the listing for rent, who's going to be the resident agent. And our company policy is we don't want you to be the resident agent. As the listing agent, there's a certain amount of liability that goes along with it. It's for service of process. If somebody's trying to sue the landlord, serve them with official papers, could be from the tenant or from anybody. That's what it's for. And there is a form for resident agent, and this is spelled out in the Virginia Residential Landlord Tenant Act. There's a form you can download from the SCC site that is one pager, very simple, but it's supposed to be completed by the landlord and provided to the SCC. You can upload it back right on the site.
And
So
if
it-
you have a property manager, does that
Property
fulfill?
manager, professional property manager, yes. Typically, they do act, that's one of the roles they fill, for sure, okay? It could be, I think the law says resident of Virginia, right?
Right.
Resident.
Resident.
And it's, what's a little gray for me, or has been, is when are they required to have and maintain an office?
Right.
I guess that's if it's a company. And what we advise, truthfully, a lot of people, some of you are very familiar with it, there's plenty of resident and registered agent services that are available. But just a lot of agents they conflate resident agent with limited service property manager. You know what I mean? Because a lot of times listing agents agree to be that go-between intermediary for their out-of-state, whether the landlord's out-of-state or not, to be the one that gets the calls from the tenant in the middle of the night, or to help the client with getting, contractor estimates, repair estimates, that kind of stuff. Those are activities that are part of typical property management. Checking on the property, doing inspections of the property, that's a component of property management. Property management in Virginia doesn't require a license. There is no license for property management in Virginia. Our policy is, it really comes down to, if you're filling that role in any way for your client because you like providing that extra level of service, whether you're charging for it or not, that's not service that is regulated by the real estate board. It's not licensed activity services. And we don't do limited service brokerage here. We frown on it, really, but there are examples of it, real world, and that's one where maybe the landlord's your neighbor or your good friend, and you do check on the property for them from time to time. So it's a form of limited service property management, but don't be collecting rent. Rent, if you collect rent, that's prohibited by our company policy unless you have a broker's license and you are set up as a professional property management company. We would prefer that you refer those into Samson Property Management. The risk goes exponentially up, as you can imagine, if you're ever collecting rent into your own account or even taking a check.
Or holding escrow.
Yeah. Yeah. But,
security deposits.
So that's resident agent. Remind your clients they need one, okay, and they're supposed to, that's state law.
So if your neighbor is going to be your resident agent, do they have to register?
Yeah. A
lot of times, right, you put the neighbor's name down in there, right? But they have to there's a process for them. They have to register.
I believe the lease speaks to this. The NVAR lease. A lot of what we talk about in here, not to be the principal or whatever. Read the documents, right? Get familiar with your documents, because a lot of times the answers to your questions can be found in the fine print.
Thank you, sir.
Dave Werfel.
Hey, so
You
this
stump
isn't-
me, I'm stumping you.
No, it's not really a stump the broker, but it's actually come up just twice in the past 2 days. Can you talk about the $4.95 fee for unrepresented?
You mean the 345?
$3.45. I'm sorry.
Oh,
Yeah.
gee, thanks.
Hey, I had that question in here too.
So I'll try to be efficient with it. The email, I have a canned email on this subject that is pretty lengthy. It's one of those emails that Sarah Mormon laughs. Says, there's another one of Mike's long-ass emails. But the 345, understandably, we get a lot of pushback from agents, particularly those who have come from another broker to us and they sell their own listing. Or they've been with us a long time, but they've never sold their own listing until now to an unrepresented customer. Or they're clearly a buyer agent, they got a buyer agency agreement, and they're working with a FSBO, a forced sale by owner. In those cases, whether it's a client or a customer, unrepresented customer, we're looking for the 345 fee. So we look at that 345 brokerage service fee as minimum company dollar per transaction side. And we've always looked at those deals far more common probably to sell your own listing. And I could go way down the path of dual agency versus not. We want you to avoid dual agency whenever you can because it's usually not justified or needed. So typically, if you sell your own listing, we would hope that it's being sold to an unrepresented party. They sign that disclosure brokerage relationship for unrepresented parties, just like if you're a buyer agent and you're working with a for sale by owner. Same form, disclosure brokerage relationship for unrepresented parties. We also have our form that's called brokerage service fee explained. Brokerage service fee explained, 345. And I wrote that years ago. I remember plagiarizing some from a Long and Foster document that way back in the day, because there was a time in the history of Samson Properties or Samson Realty where we were like, we don't have those junk fees, right? We didn't believe in them. We kind of slammed some of our competition a little bit for charging $495, $595, whatever amount as their admin fee. Well, truth is, when we went to a 100% commission plan, we rolled in Cardinal Club, because we used to be on 80-20 splits or whatever, and so minimum company dollar, $345. It really has nothing to do with representation. That's what agents, and I get it, I've had it a lot. Many times, enough times that Donnie's like, talk to Mike, or, it really doesn't have anything to do with representation. Because that's what people say. They say, how can we charge a brokerage service fee or a 345 fee to somebody we don't represent? It's called a brokerage service fee. And we are providing services. We're providing valuable services to that unrepresented customer. They know they don't have an agent. 9 times out of 10, I mean, let's face it, they know they don't have their own agent. And if they placed a super value on representation, they'd have their own agent, right? And very commonly, they come in with their hand out, looking for a piece of your commission, right? Or they, in the hyper-competitive market that we've been in, they maybe they've lost too many times in a competitive bid situation as a buyer through their buyer agent, maybe through no fault of their buyer agent, but maybe their buyer agent let them down, and maybe their agency agreement's over, or they've been talking to too many of their friends, and they're like, I'm going to go straight to the listing agent because I believe I've got a better shot at getting this nice listing that just came on the market or is about to come on the market. Better shot at getting it, and better shot at getting it at the best possible terms if I don't have an agent that needs to be paid. One way or another, they got an angle, usually. And they're not valuing representation. So this isn't representation, but they cannot deny that the company and you as a listing agent aren't pulling double duty, right? You're providing extra services than you would if there were 2 agents involved. The other factor is, from a statistical standpoint with E&O, and we get involved in a lot of E&O disputes. I've been the point person for our E&O claims and complaints and lawsuits forever. There's a much higher statistical chance of a problem, a complaint, whether it's a lawsuit complaint, an allegation of failure to disclose defects against the listing agent, against Samson, or whatever. Higher statistical chance of that if there's only one agent in the deal. So there's these reasons why I've had to restrain myself a few times by saying, wait a minute, so you've got both sides commission on this, congratulations. You didn't give away any of your commission to that unrepresented buyer, good for you, right? You're making 30 grand on this, and you're Cardinal Club, and we're talking about a 345 fee because you didn't have the knowledge or the courage or something to explain it to that unrepresented buyer. I firmly believe that if an unrepresented buyer or a FSBO, they're not going to walk away from a deal over this 345 fee, which is a company fee. It's not negotiable. We spent a lot of time tweaking the brokerage service fee explained document to try to make it easier for you to get them to sign it. Bottom line is, we don't want our accounting office to surprise you by taking it out of your commission because you were not aware of the policy. And it is in our policies and procedures, and so that's that. Any questions on that?
Both sides, there are two 345s?
Right.
And what form is used for, of course, as the listing agent, we know we got to pay it as part of our commission sheet and whatever, but what's the form that the buyer signs? What's the name of that form?
So that's a good point. And so first of all, when it's your client, if it's a listing, if it's a seller and we have the listing, there's a spot, and I like what NVAR, I don't know if you're an NVAR member, but they just updated their listing agreement they improved it under the broker compensation to make it more clear on the brokerage service fee. They actually call it that now.
Paragraph 12C.
Yeah, it's not.
Why'd they say cash though?
Everything's in cash.
I know, but throwing everybody off.
The buyer agency agreement too, if we have a buyer client, it should go in there. What I ask is that you put it in both places. If it's a client, you put it in the brokerage agreement, but you also get this brokerage service fee explained document. Obviously, if it's an unrepresented buyer buying your listing, or if it's a FSBO seller, there's no brokerage agreement. There's just the disclosure of brokerage relationship for unrepresented parties, and then there's broker service fee explained. Cardinal Title, for example, and many title companies will not, they're reluctant to put a 345 fee on the ALTA, on the unrepresented customers column, unless they've got something in writing where that person agreed to pay it, right? That's why we have that form. And we would never want anybody, whether they're a client or an unrepresented party, to be surprised, taken by surprise at the settlement table. That would be so unprofessional. So the time to address it is during your buyer interview or seller interview, and or no later than when you write an offer. No matter what the commissions look like. Obviously, we have a lot of agents that they've made the personal decision to go ahead and absorb that. That's fine. I respect that if that's what you want to do. You see, but if you do that, if an agent ever decides to cover that 345 fee, at least what I recommend that you do, if you're going to do that, ask the title company to put it on there and then show a credit back from the agent. Get credit for it, where credit's due. If you're going to pay that, because what the clients and the customers don't know is that we're on 100% commission. They don't know that unless you tell them, and most agents don't have a particular motivation to let their clients know that they're 100% commission, because if you tell them that, they might be in your pocket for more.
Well, also, when I have an unrepresented buyer that's buying a listing, I put a text box on the disclosure for unrepresented parties, and I write it on there. So that way they get the disclosure, and on there it says that Samson charges $345. That way it's right there, they sign it, they see it, and then that's part of the package, and then it goes to the settlement company, and the settlement company sees it as well. So that's how I do it.
But one way or the other, if you have that form, brokerage service fee explained, it's a little lengthier, but it's written in such a way to try to help you guys get it from your client. We don't want you to absorb it unnecessarily. So.
I've forgotten their signature line at the bottom.
Yeah.
Okay.
All right, there was a question in the back. Oh.
Hey, me? Good.
Yeah, Adam.
Hey, fun one. In terms of ethics.
A fun one.
Yeah. Ethics and liability for us over here. I'm involved in a lot of wholesaler stuff, and wholesaling means, you're buying a contract. Somebody negotiates to buy a house at a certain price, and then they sell me or another investor the contract at a profit, and then it shows up as an assignment on the settlement, with them getting $20,000, $30,000 or whatever it is to send you the paperwork, essentially. Liability on that, when first, when the wholesaler is an agent, I'm having a big problem with the code of ethics in protecting the public when that agent is buying the house, buying the paper at, $100,000 and selling and trying to sell me that paper at $120,000. They're just costing that client the $20,000, and then I have to sit down at the settlement table. They're not there, and I'm going to explain to them as an agent what they just did.
That's real world stuff.
It's intense, because then all of a sudden I'm saying to them, this is why you list with an agent. Now, then I get the wholesaler calling me saying, why did you tell my client what we're doing? And I said, because I have to, because I'm an agent always, and I'm having issues with this. So I've decided not to buy wholesale projects from other agents, but at all anymore. I'm just buying from unrepresented, unlicensed people, because I just feel like it's, at least then, there's not, I feel like there's an ethical component to this that needs to come under examination from an agent, for the agents that are doing this. I don't feel like it's right. And I'm having some trouble with it myself, which is why I'm pulling back on buying them from other agents who are wholesalers.
Yeah, thank you. That is a controversial, risk-laden component of our industry that has just exploded over the years. And I hear you, and I appreciate what you're saying. And if anybody ever is going to be involved as a principal, as an investor in a wholesale deal, especially if you're going to be the flipper, the wholesaler.
Oh, yeah.
We ask that you reach out first. We don't prohibit it. Some brokers do. We don't. We understand that you guys are out there, guys and gals are out there trying to earn an honest living, and a lot of opportunities out there. You can get burned with the flips, the wholesale deals. It's usually, the idea is it's supposed to be a little bit lower profit margin per deal, but lower risk per deal. To flip a contract, you're just assigning the contract, compared to buying a tear down or a beater and closing on it, investing your own money to fix it up, carry the costs and all of that. More risk, more reward, more expectation for profit, right? So the local associations of realtors, by and large, don't provide us any standardized forms for these wholesale deals, contract assignments. But it's completely legal, and they are covered under our E&O insurance, as long as you act as you would if you're a realtor. I mean, it's totally fine to represent yourself as a principal in a deal. Now, I should take a step back. It's okay for us to be involved as an agent, but our E&O does not cover any investment deal where you are the buyer or the seller as a principal in the deal, unless you have another agent as the agent of record on the deal. So I don't want to get too far off track. To go to your question, you would be the buyer, willing to pay a higher price than what this guy, you got it under contract for, an assignment fee.
And the other guy was an agent, a licensed agent.
And legally and ethically, there's nothing wrong with that agent, a licensed agent acting in that capacity, as long as they go to great lengths to disclose in writing that they are a profit-minded investor. Right. I have standardized language for this. If anybody, if you're ever serious about trying to do a flip yourself, where you get it under contract and you're going to then assign the contract without going to closing on it, in order for us to approve that as a Samson transaction, we want it to be really clear to the seller that you are.
See, it's
first of all, you got to. Anytime you're involved in a deal, you got to disclose that you're licensed, right? You're a licensee in Virginia or whatever. But also much further than that, I'm buying this from you as is. I'm contracting for it with the right to assign it. So it's, Adam and/or signs, whatever, and make it clear, just unambiguous, completely clear to the seller. It's usually an as-is thing, and I'm a profit-minded investor with full intent to assign this contract to another buyer for whatever profit I can get.
See, when we do the flip property, I have buyers or sellers that have said to me, "What's the value of it as is, sitting right like it is, if an investor were to buy it, and then what do I have to do to get it to a certain point?" So when I present the market analyses, because sometimes I'm that buyer of the as is house as an agent,
right?
But we have them sign the market analysis showing them the differences in the prices that they should be getting with certain improvements.
Right.
But I'm finding it. I had one guy almost walk out of a settlement where I was the assignee and sitting at the settlement table because the assignment clause that I had no idea how much this investor was making was over $60,000. And
you were the end buyer. You were gonna take
and this guy's sitting there with the real buyer. This was the one where he was surprised that he asked who I was. I said, I'm the guy that got assigned the contract. Well, the assignee was an agent and wasn't anywhere present and walked away with a $62,000 check at the end of the day.
Yeah.
And that deal almost blew up because he basically, to me, he stole this house.
Yeah.
And I felt like I was paying an as-is market price. I was fine with it, but he talked this guy into a price that was way absurdly low.
You can see why most investors trying to do these bird dogging these opportunities are looking for off-market sellers that don't have a listing agent to protect them, right? Obviously. It is fraught with risk, and there are a lot of situations that arise that, people need to...
Is there an ethical obligation on our end as the or the guy that's settling on it? Is there as an agent, assignee, whatever, I don't know. But the person that's finally finishing up the project.
You have no duty to the seller whatsoever.
Okay, we're always agents.
True.
So I can't sit in Olive Garden and say you should sell your house at $100,000 if it's worth $300,000. I feel like I'm always under that guise of the code of ethics. Always. I feel like
you can't. We're not allowed to lie,
right,
or misrepresent. But there's no agency relationship there whatsoever.
Okay.
If you're the assignee, you're the buyer.
I'm the buyer.
You're the legal buyer.
The end user.
Yeah. And there is no. The bigger risk in those deals, of course, is the
guy in the middle,
the wholesaler.
Yeah.
Because he's the one who went in. He or she is the one that went in and talked that seller into getting under contract with them at a certain price. So, but there's a lot of situations where that's what the seller's happy, or their heirs, the state. They just want to be done with it. Take it as is. I'm not.
Sure.
No broom clean condition. There's tons of junk in the backyard. Animal waste all over the place. You name it, right? I've even had our agents, some people that were wholesalers, literally help the seller move too. That could get into additional risk. You probably want to be careful because we're not representing that seller. They're usually a FSBO, right? But as long as the language is clear in there, that they, I have language that says, seller is aware that I'm a licensee, profit-minded investor, fully intent on assigning this contract for any profit I choose. And seller further acknowledges that this contract price there's no representation being made that this contract price approximates market value. If it's in there, it's in ink, you should be covered. So that's really interesting, though, and it makes me wonder how many times does the assigner, the wholesaler, who had it under contract, and he's going to flip it. So there's only one closing, and it's going from that seller to end buyer. How many times does that wholesaler show up at settlement or not?
With me, it's been none.
But one thing to be clear on, Cardinal Title. Certainly, I've had conversations with Bruce Stern, who's our managing attorney for Cardinal, for Maryland and D.C. I've had less conversations I want to have more with Carrie Lindsay and some of the attorneys here downstairs for Virginia. But Cardinal will do wholesale closings, but they will only do them if that assignment fee, wholesaler fee, is on the Alta. It's got to be on the Alta.
It's on the Alta as a seller paid expense.
Yeah.
A seller paid expense, but that line item is sometimes really huge, and the seller obviously had no idea that what was happening.
Right.
That's the problem. When they're sitting there saying, "Who are you?" and where's the $63,000 fee coming from?
Well, I mean, you could say, well, I'm sorry, the other guy's not here, but
It's assigned.
it's in the contract, you know. I'm just here to buy.
Yeah, I think his main concern is when it's an agent in the middle, you know, that's buying as the wholesaler and buying it at such a low price, and then assigning it to someone, and then they have to explain it to the FSBO seller at the end that, hey, you know,
Adam, that could be a ethics complaint potentially against that realtor licensee middleman.
But it couldn't come down on me.
I don't think so.
No. All right, I think we have time
Alexander?
for just one or two more questions, so we're going to try question number one over here.
Okay. Let's see if I still remember my questions. Okay. So this is something to do with FERPTA?
FERPTA.
Right.
He is trying to stump us.
Right. Well, I dealt with them last year. I represent the seller, foreign national seller, and the property price is less than $300,000. So it meet the qualification to get their 15% withholding waive if the buyer,
owner-occupant buyer.
Right.
the buyer sign
Correct.
the affidavit that they're gonna stay in that house for 3 years. Okay, my question is, well, what does it have to do with whether the buyer gonna stay in that property for 3 years? I couldn't see the connection of waiving that 15% because of that. One. Secondly, the buyer refused to sign that.
Right.
And I don't understand it either. What is the implication or liability of the buyer if they were to sign the affidavit that they're going to stay in that property for 3 years? So explain to me. I couldn't figure it out.
Okay, do we have additional prizes?
The only answer to this question is damn the IRS.
So Bowie here sounds like he already has a pretty good idea about FERPTA because you were talking about one of the thresholds for exemption. In this case, there is a foreign, what do we call it, a foreign person, as defined as the seller. And they might otherwise be responsible or fall under the FERPTA withholding from seller proceeds law, up to 15%. But if it's 300,000
or
less, that's one of the things. So if you ever have a property and this comes into question, that's one good thing if you're the listing agent, but it's not determinative in and of itself, the 300. The other point that he raised, which is, and we don't have the answer to it, I don't think.
Well, I have half the answer.
Yeah.
Right? So the buyers probably don't want to sign that form because who the heck knows what's going to happen in 3 years, right? So if they move out prior to the end of those 3 years, they could be on the hook for the tax implications by that foreign investor who sold that property to them. So that's why they're not overly excited about signing that form.
So it's understandable why they wouldn't.
That is the
Why
right
the
answer.
IRS?
Yeah, that's the right answer.
No prize for you.
But boy, yeah, I don't know. If anybody else has an idea why, what difference does it make to the IRS?
As far as why
I mean,
the
I don't
IRS
know.
does it that way?
Owner-occupant buyers are more likely, they're less likely to default statistically, But from a tax standpoint, for the government, or as it applies to that seller, that what if the IRS subsequently finds over year 2 or 3 that they should have had withholding?
Are they going to be that efficient to figure out that the guy moved out in 2 years?
Yeah.
That's not the government.
FERPTA continues to be.
That's my government.
Exactly.
You have a mic?
Yeah.
There you go.
Yes, I just have a experience with Cardinal and one of my clients. So we closed a deal less than 300. But my understanding was they only had to sign that they are a first-time home buyers. No, they had to live 3 years on the property. But I don't know. I may be wrong. But
3 years.
I never heard that they had to live 3 years. So
This is some affidavit.
Yes.
At the settlement.
Yeah.
Sorry, I don't really know. Carrie Lindsay and the attorneys downstairs have become a little bit more forthcoming with answers to some FERPTA questions, so don't hesitate to reach out to them. There have been times, though, when she has referred me and others to a law firm in D.C. that specializes. They are known as the FERPTA experts in our region, and I think it's Kaufman in D.C. But isn't it fun? You could dig into IRS code, try to figure that out. Yeah.
All right, anybody else?
Yep, Nizar.
no, I was waiting for just clarify.
Oh, no, you can't ask a question.
Oh, I know.
Go
I
on,
can go
Myra.
to your office. No, just to be clear about getting back to the 345 fee, because if I am working with a unrepresented party, because I have that question,
Yeah.
and they say brokers fees, so if the other party is unrepresented, so how can I explain then they say broker's fee?
It's a broker service fee.
Brokerage.
Okay.
We're not their
Brokerage.
broker. I mean, we're not their
Brokerage.
agent.
Brokerage.
Brokerage service fee. I encourage you to read the form again.
Okay.
The form is pretty self-explanatory. But if you ever need it, I mean, I also have an email that I'll fire off to you that pretty much explains as best as possible from the company perspective, but also gets into you are providing services to those people, are you not? Right? You're shepherding, you're making it happen
Right.
for them.
Did you
Without
write,
you.
Did you write the contract for them? Yes.
Yeah.
Did you sit through a home inspection with them? Most likely. Did you check on lenders? Yes. Did you provide services? Yes. That's 3 yeses. You know what 3 yeses equals? 345.
We got another one. Nizar.
See, I'm waking you guys up after that, right? Yeah. A little humor. We're all awake now. Where's the caffeinated drinks?
Real quick.
Our captain of the Prince Center, Nizar.
Hi.
And Samson, realtor.
So I may be going on an appointment, meeting a future potential client. And I mentioned it to Dave Warhol, but I'm going to ask again.
You're going to throw him under the bus?
No. So the question is, this property is kind of an inheritance property, but the property, actually, I looked it up, is actually in the name of a company. And the principal that is in the company now, he would like to sell it. And he's the principal. At this point, I do not believe there's like an executor of an estate, because he's part of that company. Basically, his mom was the CEO, and now he's taking the reins as the CEO.
Okay.
And it's in the name of the company, and the property is in D.C. So in this particular situation, besides having the company name and verifying that he is the principal in the company, do we need any other documentation?
So, I mean, like an LLC, is it, or a corporation or something?
It's a corporation, I believe.
Yeah.
I'll look it up. I think it's an LLC.
If it's very common to be an LLC, we're going to need our file review is going to be looking for signature authority by whoever's signing, the member, managing member or member, and that's typically included in an operating agreement. So we encourage you to, whenever you're dealing with a seller on your listing appointment or even before, or with a buyer, if they're going to be selling and it's owned by an entity, we need a copy of the corporate document that sets forth the signature authority, and that would be the operating agreement. In Virginia, crazy as it sounds, an operating agreement is not required. It's not required by law, at least not for a sole member, LLC. A lot of them don't have operating agreements.
Right.
So where does that leave us? Articles of organization, you can pretty much always find on the Virginia SEC site. Just look up the name of the company. VA SCC entity search. Whatever public documents are there, it's pretty rare you'll find an operating agreement. But articles of organization will usually show who was the organizer, and we'll take that.
Right.
If the organizer
Is the
in
same
the SEC
person.
records is the same person that's signing, we'll take it.
But in this case, most likely the COO or CEO or whatever passed away.
Yeah.
So that son would have to be an authorized signer in order for it to be a smooth transition for you.
Corporate resolution that was in place before she passed. A lot of people don't understand also the power of attorney it's no good after somebody dies. But happy to talk further, and it's a good question for Brand Mahoney or Rob Bodine or one of the attorneys downstairs or Cardinal. But we do get them all the time, and best to act early on. You don't want to be scrambling for that after closing just so you can get paid your commission. And, this is a no-brainer for a lot of people, but something we deal with every day. Anybody that signs brokerage agreements, please do not have your documents signed in the name of the LLC or the corporation. Right. It's got to be it's got to be an individual human signing who's authorized on behalf of that entity. But
And SkySlope allows you to do that now. So, hey, right? SkySlope is evolving. So you can do that now in SkySlope. You can put your business entity name and then whoever's the signer, and guess what? When they get it, it's in their name, right? And they can sign. So if you're still using Dotloop, it's time to come over to SkySlope. That's a plug from our sponsor.
I have a question.
We have a question left?
Yes, very, very simple question. So when we have on the addendum, so the items need to be fixed by the licensed contractor, do we need to provide just an invoice or the license as well of the contractor?
Are you speaking to the role of a listing agent and the seller?
Yes. Yes.
Yeah, home inspection items.
Yeah. I mean, I would say it's an excellent best practice as a listing agent to be proactive for sure. Remind your seller, whoever's going to be calling in the contractors to do the work, document beforehand that they're duly licensed. Everybody should know you can look up licenses, contractor licenses, I think in any of our jurisdictions online. In Virginia, it's DPOR, same place where we find our licenses. Class C, Class B, Class A. I think to answer your question, yes. Be prepared to provide that, unless, like if the invoice says, a professional contractor, they're licensed, you'd think that they would have it on their
most of them do.
Their invoice,
Yes, they do have their name, the company name, and all the contact information. But when I asked if they have the license, they said it's really the handyman work. It's just
right.
A screw two screws, and that's it.
That's where you as a listing agent, the listing agent has to explain to their seller that they have to use a licensed contractor to do the job, specialized in that particular area, right? So, but I would say if you're the listing agent and your seller wants to hire a handyman or whatever for certain things on the list, make notes on that home inspection addendum that this to be performed by a handyman.
The seller
This to
can do it
be-
himself.
Right,
herself.
or to be done by my, whatever. And then that way there's no mystery at the end of the day when you go to provide those receipts to the buyer agent and they say, well, what about all these items? Well, the seller did it himself, or the seller hired a handyman. You mean this? They hired a handyman to do this? It says here at the bottom that they're supposed to get a licensed contractor. That's where you have the dispute.
Another thing that some agents get tripped up on, or more often it's the seller that thinks this is okay. A business license,
right?
That's not a contractor's license, right? A lot of these handyman people they might have a business license, but that's not a contractor's license. So be aware of that.
All right.
Come on, keep them coming.
Really?
Yes,
No.
ma'am.
Yeah, this is a transaction I had recently, and basically, I let my buyer loose, and he went and roamed around open houses. He found an open house and ended up speaking with the open house agent. The agent informed him there was an owner looking to sell their home off the market. So, and the reason was because they've accumulated, quite a large amount of items, and they don't want their photos on the marketplace, basically. Luckily, the buyer is very loyal to me. So he came back. I did some research. We ended up at the house. We got the viewing. Now, I have two questions. One, can I be a very motivated agent and try to represent both sides as a dual agency, or is that kind of off limit and something you shouldn't touch?
The first question is
That's a
why.
great question.
The question is why would you want to be?
Well, we get it. The reason you would want to do it, maybe, is if it doesn't work out with this buyer, you want to list that property. You want to be that listing agent. If it doesn't work out for your buyer, my ask would be that you remember, okay, you got a buyer client. That's your exclusive client. There shouldn't be a need to do dual. We want to discourage dual. Doesn't mean you can negotiate the commission, whatever you can negotiate. But the seller, we would ask, remain an unrepresented customer, a for sale by owner customer for that transaction. Whenever you're dealing with a FSBO, or if you're selling your own listing to an unrepresented buyer, you got to be real with them. You want to be genuine. You want to convince them, A, you're a pro, B, you're honest, you're ethical. Your goal is to create a win-win, successful transaction. You want both sides to be happy with your services as you build business relationships for the long run. Nobody's more motivated than you as the realtor to have that kind of joyful settlement, mutual satisfaction, and get their referrals down the road. But they don't need to be a client. And 9 times out of 10, they'll know you've got a buyer and they want to sell. If they don't want to sell, they're not going to talk to you. So you can tell them, Code of Ethics and License Law requires me to be honest, because it does. You can't lie. We can't misrepresent, like when you sell your own listing, you can't misrepresent the condition of the property, whatever. Guys, got to go. Thank you.
See you guys later.
It's finesse. I mean, and it takes practice. You can tell them, if it doesn't work out with this buyer, hey, I would love to be your listing agent. Let me show you the value that I bring to the table. But if you got a buyer right now, your goal is to get that buyer in there. As soon as you become a listing agent, first of all, dual agent, you're a watered down, wet noodle non-agent, facilitator, basically. I mean, because for the seller, for most sellers, their best interest is to put it in the open market, right? To get them top dollar. Well, when you're a buyer agent, that's not necessarily your goal, and you don't have any ethical obligation on that front, right? So I don't know if that helps answer. We ask, it's the same thing as when you sell your own listing. Don't automatically gravitate to dual. Trust me, over the years, I've run into a lot of old pros, a lot of really strong agents who've great track record as listing agent, and I came to find that many of them were, they didn't have their head around agency that much, and they would automatically default to dual whenever they sold their own listing. And it takes a lot of thinking about it, but selling your own listing does not equate to dual, and working with a FSBO obviously doesn't equate to dual. So I say keep your agency singular whenever you can.
So here's where the table turned. They did have an agent. So we found that out later. The wife did sign an agency agreement. The husband wasn't aware of it.
Yeah.
So what ended up happening was they were trying to get out of the listing agreement because they realized now we don't need that listing agent.
Yeah.
So my second question is, could they have done that? Because I'm trying to think for the future, if I ever have a similar situation, can they request to get out?
And it's funny that you found out about them by way of another agent that was doing an open house, right? Told your
Right.
buyers about these people. So you got to be really careful to never, like,
Interfere.
You don't want to be getting in the way of an existing agency relationship.
Mhm.
That's Article 16 Code of Ethics. You don't want other agents doing that to you.
Right.
But if you are asked, the way you answer it is they need to talk to their broker. They can go to the broker. They don't have to just go to their agent. And there may be ways for them to terminate their brokerage agreement. You can talk with them. Crazy as it sounds, we are actually ethically, Code of Ethics allows us to enter into a written listing agreement if approached by a seller. I don't recommend it, so please don't do it, but it's possible to enter into a new brokerage agreement, listing agreement with a seller. In that agreement, it says this is to be effective upon expiration or termination of the existing brokerage agreement. Yeah, I mean, that's when the seller approaches and says, hey, I really want to work with you. You came highly recommended. How do I get out of my brokerage agreement? You got to be really careful. Don't tell them, here's a listing agreement or amendment, or here's the new form that just came out. Termination of brokerage agreement, right? Just tell them to talk to their broker, but you can help them once they're free of that.
And then to add on to your question, if you're the listing agent, how do you protect yourself from that? The early termination section of your listing agreement, which has an early termination fee, 0 should not be the number that you put in there. So if you want to make sure that you're going to get some monetary value when you're in a listing agreement, and then say before you hit the market you get a notification from your sellers that they want to get rid of you. Well, okay, it says in here I'll release you, or you want to pay the X amount of dollars and we'll release you. Plus also staying in touch with your clients would also probably help, but early termination in your contract would help as well.
I'd like to take a poll company-wide one of these days and see what are the majority of the buyer agents doing? Are they putting, with buyer agents and or listing agents, are you going with an early termination fee? Are you leaving it blank? Are you putting NA? Or what are you doing?
And from the ones I sign, I see a lot of zeros. I see a lot of zeros. But you don't have a microphone, so we can't answer that.
That's all right. If we want to keep talking about that, that's all right. Okay. You are representing two buyers that want the same property. What are your pitfalls? How do you solve it without just handing over a big commission and getting a small referral for somebody you've worked with for a really long time?
Fun stuff, yeah.
So your buyer agency agreement, right, says in there, and it tells your buyers that you may be showing the same property to other prospective clients. So we've had this question numerous times, right? So you're allowed to write offers for the different clients on the same property as per your buyer brokerage agreement. However, I would recommend that you notify or let your buyers know that, hey, I've showed this property to other buyers. I have other buyers that are going to be writing offers. I'm going to put you tell me what to put in there. I'm going to put in there, but I can't discuss the other offer that I'm writing for my other buyer.
Does this work? I asked somebody on my team to represent one of the buyers just to write the contract, write the offer up so that I really wouldn't know the details. And then I figured if their offer won, I would go back to representing through closing. Does that work?
So it gets interesting with teams, designated agency, that's designated agency. And it's fine to bring another agent in. I think what Steve said is important. I think you're agreeing. If you're in this situation, do the right thing and you got to tell both clients. Say, hey, I'm a business person. This goes for listings too. I actually had the craziest call I got one time was from a seller who was angry and wanted to complain about her Samson listing agent. She was questioning the ethics of the Samson listing agent because she came home and she saw another sign, or she learned that this listing agent was going to put another listing on the same street. I think it was townhomes. And so it presented, I said to our agent, I hope you told your seller that you had another listing coming because, that's the right thing to do, right? But my point is, whether you're a buyer agent with two buyers on the same property, it happens. You're a busy professional. This is what we do. And, that's a good thing. And actually, the fact that when it's buyers, there's only going to be one. It's a lot easier than when we're a listing agent and having another listing because that's going to generate more buyers for both. But if buyer agent, I believe that if you're going to dish it off to a team member or any other Samson agent for designated rep, knowing that you don't have to, you can work them both. But if you want to do that, or if one of them, after you talk to them, if they say, I want my own representation, then it needs to be their own representation all the way through. And if you're going to get a referral fee, this is one that doesn't happen much with teams, and it's a tricky area. But whenever you're going to get a referral fee, if that buyer wins, that should be disclosed to both. To in this case, you got two buyers. If you're getting a referral fee for that buyer, if they win, this buyer should know.
So let me get this right. So if you have I had two buyers, and they're interested in the same property, and instead of writing one off or both offers, I refer one to you as my team member. You write one.
And there's a team split usually, right?
Well, so if I give that to you and say, hey, Mike, can you write this offer for these clients of mine as part of the team? And we come up with an agreement and say that client wins.
Yeah.
And I say, okay, great, and I take them back. Right?
I wouldn't do it. See, the thing is with teams, and I welcome anybody to chime in on this, but because I was never a team lead, but you're either an agent for the seller or the buyer, and as individual agents, who are you representing? Is the team representing both?
I'm representing both buyers.
Yeah, as a team or as the team lead. Yeah, if you're going to hand them off, and I get it, teams do this, team leads, especially with buyers.
Well,
right?
I just felt like the one buyer was actually being better represented, having someone else tell
Right,
him
yeah.
what to put in the offer
Right.
or change the offer, versus me, because I knew what the other person was offering. So I knew whether they were going to win or lose, and I felt like I was serving both clients better by letting them know I was going to help one and that a team member was going to help the other. And then I thought, because if that team member's buyer had won the contract, that buyer would prefer I jump back in and be their agent to get them through to closing. So I thought I was doing what was best for the buyers, and so I just wanted to make sure
That's a good
it
one.
can
It's a
even
good
be
question.
done. With-
Yeah, because there's something called co-buyer agent, just like
Well,
co-lister.
That would be
It could
the
a
other.
co-
That would be the other question too. Is when that other agent wrote the offer, did they write their offer as themselves as the agent? And even though they're under your team, they wrote it as them as the agent and under the team. So theoretically, by the letter of the law of that contract, it's their contract.
Yeah.
So I guess if you jump back in, now you have to do a sales contract addendum, changing it over to yourself.
We would do, and then actually that other person ended up not writing, so it didn't happen, but
No,
I
but
did
it's a
want to
good
know
question.
if it happened.
It's a good question.
Yeah,
But I would say you could have written both offers.
written both.
I took the all cash buyer and handed off the finance.
Oh.
So I was pretty sure I was going to win anyway.
You took the better buyer.
I didn't win anyway.
So your second buyer knew that they were second.
Well, I didn't want to tell them that. That's why I was like, what do I do? And I talked to my team lead, and
Yeah.
said what we were
Yeah. All right. Are we getting to the end yet?
Two more questions, and
I
and
got
then we'll
one
call it a
too.
wrap.
I got one too. I want for the
A
record.
question. Where do we
Okay.
stand on the 495 getting passed to the client? The 345 can be passed, but where
Oh, fun.
do we stand on the 495? Just started to see that
If
recently.
you're not in the Cardinal Club, the $495
Yes.
fee.
Yeah. So those who are not in Cardinal Club yet, we welcome everybody to be in the Cardinal Club as soon as possible. It's not a super high bar. Once you're in for good. Until you're in Cardinal Club, there's the $495 agent transaction fee, separate from the $345 brokerage service fee. We allow our agents to collect a team fee, a team marketing fee, a photography fee, staging fee, team admin fee, additional agent fee. What we don't want is that to be lumped in with the Samson Properties $345 brokerage service fee. So you can do what you want as long as it's in writing in your brokerage agreement, and they agree to it. As long as the $345 is documented separately in your brokerage agreement or your listing agreement. And again, we ask for that brokerage service fee explained document. Sometimes we do, yeah, it's more power to you if you're bringing the value to the client and they're prepared to pay your additional fees. Does that answer it?
Yes.
Yeah.
What you're saying is we shouldn't say brokerage service fee 345 plus 495.
Correct.
It shouldn't be on the same line. It
That's
can
right.
be charged to the client on a different spot.
And that's one of the things I like about the improvement to the new NVAR document. Anybody that has seen that, they've created an entirely new broker service fee. Put the $345 there. If you have a team fee or an agent additional admin fee, put that up above in the flat fee part. So X% plus dollar amount. It would be ideal if you identify it. I know what's going to happen with that. It's going to look like it's a Samson fee, which is which, The brokerage service fee is the $345.
I have a comment, not a question. And it goes all the way back to the service animals. I have a new rental listing, and my client said no pets. So I sent her an email saying, before we go on the market, I just want to let you know about service animals and how they are handled and that you cannot discriminate against them. And there's a really cool pamphlet for landlords online. If you just search for, landlord guidance on service animals, there's a pamphlet legally created just for them. And I attached that, and she replied and said, oh, wow, thanks. I didn't know about this. And I'm glad that I know, we don't have any applicants right now with service animals, but
Address it up front, save yourself trouble.
Right. Save yourself, find the pamphlet online. It's really nice. It's really nice. Yes. Mm-hmm.
Right.
I think we're right about at wrap time.
Well, I got one question I wanted.
Okay.
I have one question here I wanted on the record.
All right.
Can we get it on the record? All right. This is Mike's question.
Okay.
Mike, I had a listing recently, and my seller accepted an offer that was a VA loan, and they escalated the price up $20K, and they wrote an addendum removing the appraisal contingency. Well, long story short, the property appraised lower, and the buyer came back and asked the seller to lower the sale price of what, or they were going to void. Can they do that after they waive the appraisal?
You're not protected with the VA. You can't be bound one way or the other. Pam stumped us on this one, especially with the gap. When you get in the appraisal, having an escalation addendum and gap guarantee. Right. Well, when you got VA, these poor VA buyers have been discriminated against, and they continue to be. Any way you get around it.
FHA the same?
Yeah, FHA the same. I know we got, Justin, can we get one or two more in?
I know this is going to open a can of worms, it's the resale docs.
Yeah.
The resale.
Yeah.
I just got an offer on my listing, and someone reduced their review period to 1 day.
Yeah. So.
And well, yeah, but I just watched your video from the MBAR saying we need to stick with, what was presented before, and
our company policy is in line with what NVAR is recommending. If anybody hasn't seen it, 2 weeks ago or so, we had Arian Wahab, one of the attorneys at NVAR out here. She spoke a lot about this, and there is confusion in our market, and there's actually currently a disparity in what's in writing on this subject of the updated law regarding the Residential Disclosure Act and the buyers, whether the buyer can waive their right to cancel the contract under the Virginia POA Act or the Virginia Condo Act, because the Virginia Code was updated as of July 1, and it refers to the resale certificate, whether it's condo or HOA, doesn't matter. They're both called resale certificate now, no longer resale disclosure packet. But interestingly, for some reason, what was removed from the code on the buyer's cancellation applicable to condos or HOAs is that one line that was always there that said the provisions of this code section may not be varied by agreement. That took that out. That was what they always hung their hat on. You can't waive. It's a statutory right of the buyer. And so Virginia Association of Realtors actually came out. You can see it on their website. They have published an article that purports to allow buyers to waive their cancellation right in a competitive bid situation or modify it down to 1 day or something like that. And NVAR's position is no, we disagree. It's really unusual. They're usually very much aligned. And the attorney, Arian Wahab, said that NVAR is actively working with VAR and state legislator types and D4 and stuff to get this clarified for us as soon as possible, because technically right now there's a contradiction between what Virginia Realtors is saying versus NVAR, and it's based on that one line removed from the code that always said you can't waive this.
So we'll know the answer in 3 years?
Yeah. And the Virginia Realtors, on the same line, Virginia Realtors is suggesting also that slight change to the code now allows the buyer and the seller to extend the cancellation rights if they want beyond a maximum of 7. You know, for a few years, it was always 3 years, 3 days after 3 days after receiving. But they came out 2 or 3 years ago and said, with this form, you can extend it from 3 to 7, up to 7, but no more, right? Another one I get on that all the time is, can the buyer cancel? This is applicable in Virginia. Can the buyer cancel before they get the certificate, the resale disclosures?
Well, not
before
really.
they get them?
Not really.
The answer is yes, they can.
Well,
that lot of fights over that. People say, we haven't even given you the HOA docs or the condo docs. You can't cancel yet.
well, that would be true.
But
That contingency doesn't kick in until those docs are delivered.
But it's a statutory right, and so if you're a listing agent, don't try to fight it.
Right.
You're not going to.
I'm with you.
Obviously, you want to know why. Come on, what's the real reason you're bailing?
Cold feet.
Yes, Alexandra. Are you on? Yeah.
Okay, great. I just have a follow-up question from Amy's example where only the wife had that listing representation document and not the husband. So if you have two owners where only one spouse signs, is it
No
a
good.
contract? Is it okay? I just want to clarify that.
Right.
Is it really
Maybe
holding or not?
Maybe
So it
she
sounds
signed
like-
his name.
Yeah.
Well,
You know,
I'm not a detective,
all
but
owners of record
sometimes I
got to be on that. Otherwise, that listing agent shouldn't have represented that they
okay.
had a valid.
So you
listing
need to
agreement.
have all the owners sign
He
that.
has Alzheimer's and
Usually,
he
if
can't
it's
sign
just.
for himself.
Thank you.
Are we good?
All right. Thank you for
guys.
coming.
Thank you so much.
We'll see you next year.
Peace out.
Mom.
Peace out.